Chairman. And Chairman Murphy, General Counsel Kerry, thank you for being here with us today. As you both know, the NLRB states that if a union can recruit 30% of employees in a particular workplace to sign authorization forms stating that they wish to be represented by a union, then the NLRB verifies the forms and orders a secret ballot election. The NLRB goes on to say that a majority of the workplace's eligible employees must vote yes to have a union represent them in collective bargaining negotiations. However, the statute's vagueness on the term majority allows these elections to be decided based on the number of votes cast no matter how many eligible employees participate in the election. This can lead to absurd situations, such as the unionization election at the Virginia defense contractor Kerberos International. Only one worker out of 8 who were eligible voted to give union control of all of the workers. A similar situation happened in Washington, D.C. at the security firm Security. Only one worker out of 7 who were eligible voted, giving the union control of the whole workplace. Union organizers can easily abuse this system, focusing on a small number of workers to ensure a union victory. Trader Joe's employee Michael Alcorn testified before Congress that, quote, after an organizer realized I wasn't on board, they told me that they couldn't answer any more questions and that they were going to devote their attention to those workers who would be with them and help them win. This is not workplace democracy. Chairman Murphy, do you think this is problematic that only one worker can unionize a workplace?
I assume that this is not a case pending before me.
No, it is not. Yeah,
it's concerning. I think it's an aberration. I'm not familiar with many cases at all that have presented that drastic, a minority of votes being cast.
Yes.
But you're absolutely right. The
Yeah.
more voters, the better it is, and that's one reason why we have a preference for in-person manual ballot elections.
Yes.
Because we have the highest participation rate.
Absolutely. Yeah, absolutely. Thank you, Mr. Murphy. That is why I introduced the Worker Enfranchisement Act. My bill would provide for workplace democracy by mandating a 2/3 quorum of eligible employees to be present in a unionization election in order for those results to be deemed valid. If a 2/3 quorum is not present, then the election would be deemed invalid. With a 2/3 quorum, still 84% of unions that won in September 2024 would have been valid. This, I believe, is a reasonable reform that can ensure that all employees have a voice in workplace unionization elections. Unfortunately, the Biden-Harris era NLRB made this lack of workplace democracy problem even worse. Under the board's CEMEX decision, an employer can be ordered to bargain with a union even in the absence of a majority vote in a secret ballot election. The Biden board decided that an election result could be jettisoned based on an alleged unfair labor practice during the organizing campaign. Thankfully, the Sixth Circuit Court of Appeals struck down this CEMEX within the Sixth Circuit jurisdiction. I believe it should be struck down nationwide. Ms. Kerry, given the serious consequences of issuing bargaining orders, what steps is your office taking to ensure that bargaining orders are rarely issued, narrowly applied, and issued with clear standards?
Thank you. Well, I would argue, generally speaking, that bargaining orders are a rare occurrence. They are to be withheld for the most serious and egregious violations in relation to election conduct. So I believe that even before the prior board took the steps to, move to the CEMEX standard, there were already board cases in place that had been in place for over 80 years, quite frankly, and had resulted in a number of rerun elections. So what we are doing is we are investigating cases to the extent that they come before us in relation to election misconduct, and we are evaluating those under the standards of the current law. So to be clear, in CEMEX, there was no specificity in relation to specifically what type of unfair labor practice would result in a CEMEX bargaining order. So there is discretion when we are reviewing unfair labor practices to determine whether or not a CEMEX would be appropriate.
Thank you. I yield back, Mr. Chairman.